My lady, I'm now about to go to the equivalent of section 191 in the Northern Ireland context, the one case I mentioned I would refer to, which is Percival Price, which is MS 966, volume 1 of the authorities, so the primary authorities, behind tab 8, 9666. This is a Northern Ireland Court of Appeal case brought by a Fair Employment Tribunal judge and also an Industrial Tribunal chairman and a full-time chairman of the Social Security Appeals Tribunal. It concerned changes to the pension arrangements, which were said to be sex discriminatory. I won't trouble you with those. But just as to the appointments and the way in which they were made, I can ask your ladies and your lordships, please, to turn up paragraph 8 in the first instance, paragraph 8, which is at MS page 968. Under 1, subparagraph 1, the end of that subparagraph, the former appointment was made by the Department for Economic Development and the latter by the Lord Chancellor. So that is Chairman of the Industrial Tribunals was the Department of Economic Development, and the Fair Employment Tribunal was the Lord Chancellor. And then paragraph 10, 1. Social Security, Mrs. Brown was a full-time chairman of the Social Security Appeals Tribunal and the Medical Appeals Tribunal. Her appointment was made by the Lord Chancellor through the Northern Ireland Court Service and was funded by the Department of Health. The tribunal found, the employment tribunal that is, in the claimant's cases, found at paragraph 13, so same page, paragraph 13, question 1, that each of the applicants held a statutory office. And the significance of that can be seen from the terms of the applicable legislation at paragraph 18, MS page 969. Paragraph 18, section 19, this was of the Equal Pay Order, section 19, the Equal Pay Northern Ireland Act, Northern Ireland Act. Section 19 contains a specific provision for persons in the public service who are traditionally not regarded as having been employed under a contract of service. Pausing there, we say it's the equivalent provision of section 191. This section, it says section 1, subsection 9, this section shall apply to service for the purposes of a minister of the Crown or government department, other than service of a person holding a statutory office. So under section 191, there isn't the limitation in relation to statutory office holders. Otherwise, it mirrors closely the terms of section 191. We say is plainly directed at achieving the result that's already been identified, that civil servants, among others, are caught. And so the question was, given that limitation, an apparent exclusion, what was the position of the claimants, given that they were pursuing claims caught by EU law? So these were equal pay claims, so they had an entitlement under EU law. What was to be done about the exemption? And this was dealt with at paragraph 38. I read you, my lady, my lords, the extract earlier on when I dealt with Percy. I won't read you again. But 38, the conflicting provisions in domestic law can be simply isolated. They consist of the phrase in section 19 of the 1970 Act and the 1976 order, that's the sex discrimination order, other than service of a person holding a statutory office. This exception is for the reasons which we have given, inconsistent with the requirements of Article 199 and the directive. It has to be disapplied. That is to say, the court should, in applying the provisions of the Act and order, disregard the phrase. And that's what the court did to give effect to give effect to the directive and Article 119. There was no issue as to whether or not the claimants were providing services for the purposes of a minister of the Crown. So it proceeded on the basis that that part of the section, that element, was met in the claimant's case, or the appellant's case at that stage. The only obstacle was the statutory office exemption. We say, therefore, that is authority for the proposition that we put forward, that Section 191 is broad enough to embrace judicial office holders.
Sorry, I thought you said it wasn't. It was taken for granted.
Yes, I mean, there was
it's
no
not authoritative.
Well, there's no issue that it was accepted. That it was accepted that there was.
That doesn't take us anywhere, does it?
Well, it would have to be, because they couldn't have done what they did and given them the remedies if they hadn't.
Yeah.
So it's part of the ratio of the result of the case that the section applied.
Anyway, it's not binding on us. So
even if it was conceded.
It's not binding.
Yeah, but it isn't reasoned, so we don't know what the basis of it was, so we can't really use it.
Well, it was assumed to apply.
Yeah, no, I understand that. But
and there had been argument below. The tribunal had made findings. It had come up on the question whether or not the exemption in relation to statutory office holders was consistent with the EU law and so on.
Well, I think you can say, as my lady has pointed out, the Court of Appeal could not have made the decision that it did unless it accepted that it did apply.
Precisely.
Well, I mean, a clue to the thinking may come from paragraph 26, which is the passage that you formally read to us, but it's the bits that you didn't read maybe that tell us a bit more. As often
Hope that wasn't intentional.
No, of course not. Their office, according to the last sentence, their office accordingly partakes of some of the characteristics of employment. That was the bit at which you stopped. As servants of the state. And that's the bit I wondered about. Is that the basis for concluding that they fell within the Crown employment exception, that they are public servants of the state as distinct from civil servants?
The case appears to, as is apparent from that paragraph, and indeed the earlier paragraphs, the case appears to have proceeded on the basis that they were not workers or employees in the wider sense. Therefore, the equivalent of Section 191 was relied upon. So there's no holding to that effect, but it appears to have proceeded on that basis, and as your lordships observed, that's referred to in terms at the end of that paragraph.
The question, I suppose, is whether or not under or for the purposes of makes one a servant of the state, or makes one a, whether or not under or for the purposes of employment, under or for the purposes of the Lord Chancellor, where is caught within that provision.
Section 191.
Yeah.
We say yes for the same reasons in Percival Price. Percival Price did proceed, it appears, on the basis that they were not workers, even within the extended meaning, but it also proceeded on the basis, it seems to me, that they were capable of falling within the equivalent of 191, say for the statutory office.
In other words, that a public servant of the state, which these office holders are working under and for the purposes of the Lord Chancellor.
The wording is slightly different, as you will have seen. It's services for the purposes.
I mean, they use the term service rather than employment, but it doesn't look as though that really makes any significant difference.
Accept that.
this authority was very much relied on by Lady Hale in person, not, I think, by anyone else.
I don't recall any of the other justices relying on House of Lords or Supreme Court. I wouldn't give it any less weight for that.
Oh, no,
reason.
I mean, there's, you know, I'm not saying so, it's just it's not
Oh, I wouldn't
binding on
invite
us.
your lordship, I forgive me, to
We
give
have
it any
to-
less weight for that reason.
Our best with such help as we get from it.
And of course, your lordships makes the observation that it's not binding, but in my submission, it's all we have, and it supports the arguments that we make. And I will deal with the question you asked earlier about what would be the consequences. I'll provide you with a short note tomorrow. But I do say that the critical question is, does it apply? And if it does, well, there we
I
are.
mean, we have the difficult situation to me that, you know, for years it seems been assumed that judges were somehow exempt from all these things. Then we get this sort of case which takes a different view, and then we get Percy, which really says, throws it all open again, and here we are trying to decide what the answer is.
Yeah, I appreciate it's as a consequence of EU law, but nevertheless, O'Brien has, to some extent, shifted the way we look at judges, because not most particularly because so many of the rights contained, not just within the Equality Act, of course, but within the context of the Employment Rights Act, so many derive from EU law, like the requirement for a statement of terms and conditions under Section 1. So it very much has changed the way.
Thank you.
Since you mentioned my request for a short note, could I just clarify? I mean cases where rights depend on wording the same as Section 233 as well as 230 subsection 3 itself. So it's a slightly wider...
So that those that rely on worker status within both limbs. So
No, I mean, in some cases, that definition has been copied and pasted into regulations.
I see. So
So it's not simply by reference. You can't just do a search 230 subsection 3.
So
If I could make that clear.
I think I understand the point. So the part-time workers regulations and various working time regulations
That's right.
and so on. Yes, to
Thank you very
the
much.
best extent possible. There are thousands of regulations, but I will do
The
to the
material
best
ones.
extent possible
Yes.
the main ones. And I might even call on Protect to help me,
Thank you.
because they've
Thank
got
you.
much less to do than me, and they've got a junior. So there.
Thank you.
But yes, I will do that, and I will also, if I may, when I do that, in both cases, Section 191 and 230, I will also identify to the best extent possible those rights that derive from or are reflected in EU law,
I think you need to do that, yeah.
because many of those worker protections will have to be read in the same way as O'Brien, because EU law
Correct.
demands it. So it's not, so when we look through how wide this could be, all of these rights suddenly enjoyed by judges, the reality is, post-O'Brien, and while we're still in the EU, or at least our rights are retained, there are masses of employment rights that are now enjoyed by judges, including senior judges, as we see from the High Court pension litigation. So that is 191. I appreciate I've taken it shortly, but there isn't anything else by way of authority that I've been able to find, or indeed anybody else, it appears, has been able to find, and we rely on the terms of the provision itself. I'm now going to turn to the convention. Some of this I can deal with a bit quickly, or a bit quicker. Mr. Stillitz may pick up on some of the Article 14 arguments, so I may put those a little shortly. I will need to make my points, but I can do it a little shortly. But if I can start, please, with Article 10. I won't take you to it because I know it will be very familiar to you, but qualified right to freedom of expression. If I can take you, please, to Bates van Winkelhoff, which is Volume 3, MS 1923, MS 1923, which is Volume 3 of the hard copy, tab 41. This was a whistleblowing case, and it concerned the question whether or not the claimant, who was an equity partner of a limited liability partnership, was a worker or caught by the whistleblowing provisions, and you can deal with that. But I simply want to deal with the Article 10 arguments, and if I can take, please, your ladyships and your lordships then to MS 1935. Paragraph 41. Question was whether the claimant enjoyed the whistleblowing rights having regard to the nature of her employment. The Supreme Court held yes, so didn't need to determine the human rights arguments. May I just deal with one or two points that emerged from the judgment, Baroness Hale or Lady Hale in any event. Paragraph 41. I've reached that conclusion without the help of the European Convention, but it may be worth noting that the conclusion is entirely consistent with the appellant's rights under Article 10, whereas a different conclusion would pose more problems. Then there is a look at some of the cases, two cases in particular, which I will take your ladyships and your lordship to, so I won't read that extract of the paragraph. And then paragraph 43, hence it's argued that if the appellant's claim as to the reasons for her dismissal are made good, it would be incompatible with her convention rights for the law to deny her a remedy. That is, if the reason for her dismissal was her whistleblowing, it would be incompatible with her convention rights for the law to deny her a remedy. If the whistleblowing provisions of the 96 Act apply to her, she would have such a remedy. Those provisions are consistent with the proportionality calculation carried out in Heinisch, which I'll come to. The expectation is that disclosure will first be made to the employer or the person responsible or the prescribed regulator, and then sets out the matters that I identified earlier on. That is, these provisions are concerned with responsible disclosures, hence the proportionality threshold is that is that they are not, arguably not justified, since there's no issue of disproportionate protections. So this argument raises what might be a difficult question. Under 3.1, we've got a duty to read and give effect to the legislation which is compatible with the Convention rights, and this means that it may have a different meaning in the context from the meaning it has in others. While it's comparatively easy to see how this may be done in order to prevent the state from acting incompatibly with the person's convention rights, in other words, to respect the negative obligations on the state, it's a little more difficult to assess whether and when this is necessary in order to give effect to the positive obligations. Then 45, fortunately, the court doesn't need to determine it. My ladies and my lords, I simply pluck from that the fact that it's recognised by Baroness Hale, I appreciate it's not decisive, but recognised that ensuring that the protection extended to the appellant was consistent with Article 10, particularly given the responsible nature required of such disclosures for protection to be triggered, and also that it would be comparatively easy to see how the legislation could be read compatibly where one was relying upon the positive obligations of the state. Since we are operating in the public sector, not like Bates van Winkelhoff, where she was looking for horizontal impact, we say we can rely on Article 10 directly in terms of the negative obligation, and it's comparatively easy to see how that can be done. As to the authorities from the European Court, just two, if I may. First of all, Heinisch, which was referred to by my Lady Hale. in Van Winkelhoff, and that is at MS 1234, Volume 1, Tab 17, MS 1234. This was a whistleblowing complaint, geriatric nurse, problems with the services provided, she said, serious shortcomings including staff shortages, and at 1244, MS 1244, paragraph 43, paragraph 43, the court observes at the outset that it was not disputed between the parties that the criminal complaint lodged by the applicant had to be regarded as whistleblowing on the alleged unlawful conduct of the employer, which fell within the ambit of Article 10 of the Convention. It was also common ground between the parties that the resulting dismissal of the applicant and the related decisions of the domestic courts amounted to an interference with the applicant's right to freedom of expression. And then at 1249 to 50, MS 1249 to 50, paragraph 63, this is the court's assessment. We see that at the page before, court's assessment. As regards the application of Article 10 of the Convention to the workplace, the court has held that the signalling by an employee in the public sector of illegal conduct or wrongdoing in the workplace should in certain circumstances enjoy protection. That's the court's jurisprudence. This may be called for in particular where the employee or civil servant concerned is the only person or part of a small category of persons aware of what is happening and is thus best placed to act in the public interest by alerting the employer or the public at large. And then I won't read you this, but in essence, paragraph 64 deals with the responsible disclosure issue. In other words, there are matters like loyalty and so on, against which disclosure must be weighed. And then paragraph 65, consequently, in light of this duty of loyalty and discretion, disclosure should be made in the first place to a person's superior or other competent authority or body, and so on. And then there is a reference to a proportionality analysis being required. This is a qualified right, so paragraph 66. Court must also have regard to a number of other factors when assessing proportionality of the interference in relation to the aim pursued. In the first place, particular attention should be paid to the public interest involved in the disclosed information. Reiterates in this regard that there is little scope under 10.2 for restrictions on debate and questions of public interest. So clear that under the jurisprudence of the European Court, that whistleblowing, responsible whistleblowing, is caught by Article 10. And one further case, and this concerns judges and whistleblowing, this is MS 3111, MS 3111, Volume 6, Tab 76. And this is Kudashkina against Russia. And it concerned a judge. We can see the facts at page 3111. Applicant had been a judge in Russia. Applicant was permitted to suspend her role as a judge and campaign for a seat in the State Duma of the Russian Federation. During her campaign, she gave interviews in both radio and television and in the print media in which she described the Russian courts as instruments of commercial, political or personal manipulation. She referred in particular to a case over which she presided. She wasn't elected and was reinstated as a judge. And then the Judiciary Qualification Board decided to terminate her office as a judge, alleging that she deliberately disseminated deceptive, concocted, etc. Allegations. She claimed that her removal violated Article 10. If I can ask, please, that your ladyships and your lordships turn up MS 3132, paragraph 82, 3132. And again, in determining whether or not there was a violation, had regard to the fact that the right was qualified, they had already found a legitimate aim. Question was whether or not it was necessary in a democratic society. Paragraph 82 dealt with the factors that were relevant to that assessment. Roman numeral 1, freedom of expression constitutes one of the essential foundations of a democratic society. Roman numeral 2, the adjective necessary within the meaning of Article 10.2 implies the existence of a pressing social need. Roman numeral 3, the court's task in exercising its supervisory jurisdiction is not to take the place of competent national authorities, but to review under Article 10 the decisions delivered. Doesn't mean the supervision is limited to ascertaining whether the respondent state exercised its discretion reasonably carefully, but a proportionality analysis required. And then at 83, in addition, the court reiterates that the fairness of the proceedings, the procedural guarantees afforded, and the nature and severity of the penalties imposed are factors to be taken into account when assessing proportionality. And then 3136, so there's a proportionality analysis, mindful that freedom of speech is a particularly important right, and of relevance to the proportionality analysis will be the impact on the appellant of any punitive measures. And then 3136, paragraph 94, noted that the applicant made the public criticism with regard to a highly sensitive matter. And then paragraph 95, insofar as the applicant's motive for making the impugned statements may be relevant, the court reiterates that an act motivated by personal grievance or personal antagonism or the expectation of personal advantage, including pecuniary gain, will not justify a particularly strong level of protection. Pausing there again, that reflects the whistleblowing protections under the Employment Rights Act. And then at paragraph 99, MS 3137, paragraph 99, the court recalls the chilling effect that the fear of sanction has on the exercise of freedom of expression. This effect, which works to the detriment of society as a whole, is likewise a factor which concerns proportionality of, and thus justification for, the sanctions imposed on the applicant, who, as the court has held, was undeniably entitled to bring to the public's attention the matter at issue. So the absence of any protection for the punitive measures that she experienced for expressing or disseminating information in the public interest. Accordingly, it's the court's assessment that the penalty at issue was disproportionately severe and moreover capable of giving rise to a chilling effect. So robust protection for public interest disclosures, even in the context of such a sensitive matter like the administration of justice by a judge. My client didn't suggest corruption or anything of that sort, but nevertheless, there were serious allegations have been made about, for example, risks to health and safety so far as judges are concerned. So we say protection is afforded by Article 10. There must be some proper justification if that protection is not to be provided as a matter of domestic law. We say if protection is not afforded the appellant through the Employment Rights Act, there's no other effective remedy. There's nothing in the internal regulations or guidance which would permit her to make public interest disclosures and have them addressed. We know that from the reports of Lord Justice Tomlinson into her grievances. And we say she has no adequate alternative remedy. You will have observed that the Court of Appeal considered that the appellant should exercise any right she had under Article 10 through a Section 7 claim. We say that is not an effective alternative remedy. Firstly, it's an uncertain remedy, so far as compensation is concerned, as this court will know. And nor does it reflect the protections that Parliament has decided to afford where there are public interest disclosures by way of a specialist tribunal, generous compensation for injury to feelings, and an accessible system which doesn't now require a fee to be paid. Compare the County Court and the High Court. So in our submission, the absence of protection provided through the Employment Rights Act, if that be the consequence of the court's ruling on Section 230 and Section 191, violates the appellant's rights under Article 10, and this short court should strive to give a meaning to either Section 230 or Section 191, which affords her proper protection. And in our submission, that can be done. Doesn't go against the grain of the legislation, as the Employment Tribunal suggested, far from it. In the context of Section 230 and the requirement for a contract, as I have already demonstrated or shown the court, in some cases there isn't a requirement for a contract at all to enjoy the rights under the public interest, the whistleblowing provisions. Sorry. So the requirement for a contract, if Section 230 is the vehicle through which protection is provided, can barely said to be a fundamental aspect of the whistleblowing provisions or a fundamental threshold, since we know they can be enjoyed in certain circumstances in the absence of a contract at all. I also remind your ladyships and your lordships that Lord Justice Underhill concluded himself that it would be possible to read Section 230 in a way that protected the appellant if it was necessary to do so in consequence of Article 10.
Could I just ask you one thing about the claim? You've taken us very briefly to what it was that she was complaining about. And I've read that in any event. You didn't, however, mention what detriment she was specifically complaining about.
Well, I should have taken you to that then. She made complaints in her originating application, so in her claim form, that in consequence of the disclosures, she had experienced bullying and so MS 295, page 123 of the internal pagination. She avers under paragraph 52, last sentence, that she was subjected to the following detriments as a result of raising these public interest disclosures, and then she lists them.
Thank you.
That leaves me with Article 14. Article 14, as I know this court knows very well, is the Convention's non-discrimination guarantee. Just in determining what's not in issue, it's not in issue that the claim falls within the ambit of Article 10. So the questions below concern difference in treatment, protected ground in particular, and analogous situation, and then justification. May I just take you, please, to the Court of Appeal's judgment below, so as to identify those issues. That's the core volume, MS 215. That's internal numbering, page 40. And we'll see at paragraph 102 onwards, Lord Justice Underhill sets out the classic tests. I needn't take you to them because you'll be very familiar with them, but the Michalak, Gaydan, and then the AL Serbia and Carson approached. I can deal with those each if the court would find it helpful, but I know this is referred to so much, I'm sure you could recall it in your sleep.
Take it as read.
Paper's read, take it as read, yes, well, quite. I'm not going to take you through all the...
Mark learned and internally digested, yes.
I'm sure
Several
that,
times.
yes, I'm not going to take you through all the Article 14 jurisprudence. I take it as read that you know it very well. But just where the court below found against the appellant and what the answer to that is, MS 216, so in terms of the setting out of the law, the legal tests, no issue taken with that. And then at MS 216, so over the page, paragraph 117, this is Mr. Stillett's. You'll have seen below that Protect took the lead on Article 14. And this dealt with the question whether or not there was a protected characteristic which fell within the concept of status under Article 14. And Mr. Stillett's put the case like this at paragraph 119. Mr. Stillett submits that the position of those working other than under a contract within the meaning of Section 2303 of the 1996 Act should be recognised as a relevant other status for the purposes of Article 14. Alternatively, he submits that the relevant status is either that of a person holding judicial office or the larger class of office holder. The court didn't accept those submissions. But in other words, if I can summarise it, contending that there was a class of people protected in relation to the whistleblowing provisions and another class of people working who may wish to make public interest disclosures who were not protected. And he contended that that class, just as the first class, afforded a status for the purposes of Article 14. Court held otherwise. Paragraph 120 seems to us that the legislation in question does not draw a distinction based on belonging to a class of judicial office holders or indeed office holders as such. Important to keep in mind that Parliament has not discriminated against either office holders generally or the subclass of judges. What it's done is defined worker and drawn the line in such a way that the effect is that all those who don't have a relevant contract with the meaning of that definition fall outside the scope of protection. Well, that's
drawing a distinction.
That's drawing a distinction dependent on class, that you're either in or you're out. Leave justification aside, but we say there is plainly a distinction and there is no reason to suppose that the status relied upon, that is, you're not a worker, you're not in Crown employment as opposed to you are, There's no reason to suppose that that status is not one which would be protected under Article 14, except that there'll be issues about justification, which I'll come to, but there's no reason to suppose that that status won't be protected. And in my submission, where Lord Justice Underhill went wrong, or indeed the whole court, it's judgment of the court, is apparent from paragraph 121, so MS 217. Secondly, the distinction which is in truth used by Parliament in defining the scope of protection is all to do with having a relevant contract and nothing to do with personal characteristics. Now, the status requirement under Article 14 goes much wider than personal status or personal characteristic, forgive me. It goes to legal status, some of which this court will be, well, all of which this court will be very familiar with, immigration status, citation, married as opposed to unmarried status, see McLaughlin and G. And from the European Court, Van der Mussel, which concerned barristers, pupil barristers, having to do pro bono work, you may recall, which they were very unhappy about. There was a requirement that barristers undertake pro bono work, whereas doctors and other professionals were required. I should say the barrister didn't succeed. But in any event, it wasn't contended that that was not a protected status. And then military status or rank in Engel. These are all in the printed case. But simply to make the point that legal status, that is how one is characterised in law, may be just as much a status for Article 14 purposes as those matters that touch closely on human personality, race, gender, etc.
There may be a distinction in the difficulty of justifying the distinction.
Precisely. And I come to justification, and I recognise, of course, it's not we're not in the territory of suspect classes, and I wouldn't contend otherwise. But
the first step is identifying whether you come within
precisely
the rubric status. And that's your essential criticism of the Court of Appeal's judgment.
And so
I mean, how can it be said that judges do not inhabit a status?
Well, we'll listen to the argument.
The complaint, of course, was simply as
it's putting it in a provocative way.
Yes. Anyway, the line was drawn, and where the line was drawn was said to be discriminatory. There's a line drawn between two classes of people undertaking work, and there was a distinction that the court recognised, but simply...
Well, the point is you've got to take it in stages. First of all, identify the status, then decide whether there's been a difference in treatment, and if there has been, then turn to the question of justification. But you've got to take those separate stages separately.
And it's important that a proper stage-by-stage process is adopted, because otherwise one gets into the difficulties which in my submission Lord Justice Underhill got into. But Lord Justice Underhill then went on to consider analogous situation. And I don't need to remind the court, but of course that's a problematic concept, and very often the court goes straight to justification. But in any event, considered analogous situation.
The analogous situation is generally looking at are they in an analogous situation for the purpose of the way in which they've been treated? Yes. You're a whistleblower.
Yes. And Lord Justice Underhill says, no, they're not in an analogous situation, that is judges, paragraph 124, for example, because at least some of them will have the right to bring proceedings under the 1998 Act. Some will not, some in the private sector will not have the right to bring claims under the 1998 Act, whereas judges will. In my respectful submission, that's nothing to the point. The question is, are they in an analogous situation for the purposes of requiring protection in relation to whistleblowing? They are in an analogous situation.
it could be, I mean, that could be relevant to justification.
Precisely.
You know, if you are adequately protected in other ways, well, then you don't need the protection of the whistleblowing proportion.
But for the first stages, there is a distinction. It is a distinction drawn on the basis of status. The needs of those falling within, as well as those falling without, for protection in relation to whistleblowing can't be regarded as any different, particularly having regard to Article 10, but in any event. And therefore, one turns to the question of justification in my submission. And Lord Justice Underhill, until then, fell into the errors that I've just outlined or submitted. The question then was justification. And in my submission, the Court of Appeal went wrong there too. If I can just, before I come to the Court of Appeal's judgment in relation to that, just to make the point good, can I first set out what in my submission is required by way of justification, or what is the staged approach? I won't take you to all the case law, but first of all, what has to be justified, and this is still a bit controversial, it seems to me, we would submit that what has to be justified is the discrimination, that is the discriminatory nature of the measure. I know, my lady, that in DA, which was only handed down on the 15th of May, so isn't in the case, your ladyship indicated...
Well, that point is neither here nor there in this case, because if this is discrimination, well, it's direct discrimination.
Yes.
Whereas what I was getting at in the benefit cap cases was that in indirect discrimination, it's the rule or practice that has to be justified rather than the discriminatory effect.
I see.
So
well, then I read it as being rather wider than that. But in any event... Well,
I don't think so.
Well, then that was my misreading. Well, then there will be no controversy around that then. One has to justify the discriminatory nature or the discriminatory aspect of the measure, not the measure itself. The measure itself, the protection against whistleblowing, is not only benign but a very good thing and readily justified. It's the discrimination that must be justified. As to the test for justification in this context, you will have seen from the Court of Appeal decision, which I'll come to, but also from the respondent's case, that they assert that the proper test is whether or not where the line was drawn, the discrimination, was manifestly without reasonable foundation. The manifestly without reasonable foundation test in my submission has absolutely no role at all to apply, no role in the context of this case. This case is about the rights afforded people in work, whatever that work may be. It is not the social and economic policy making that one sees, for example, in the paradigm cases, the benefits cases. This is a workers' rights case, put broadly, and the manifestly without reasonable foundation test is of no application whatsoever. If authority were needed for that point, I don't need to take you to it, but if authority were needed, a WEDA is the easiest one. That's at MS 1220, starting at 1188, but the relevant part 111220, Volume 1, Tab 16, at paragraph 88, 1220, paragraph 104, MS 1223, paragraph 106, MS 1224, and paragraph 109, MS 1225. And just to remind the court of the Awida case, that was the case, the three cases that went to the European Court of Human Rights in relation to religious discrimination and sexual orientation discrimination, principally religion, but context of sexual orientation, as it so often is. And the question was whether or not the various actions taken against employees by employers in relation to the exercise of their rights under Article 9 was proportionate or disproportionate, and an ordinary proportionality assessment was applied. There's no manifestly without reasonable foundation test in the context of basic employment rights, whether they engage convention rights or not. So then one is left with an ordinary proportionality analysis. In my submission, I accept, as your ladyship's already alluded to, that the status relied upon is relevant to the degree of scrutiny. So one is not here concerned with strict scrutiny, as one might be or would be in the context of gender, race, sexual orientation, for example. But nevertheless, a proportionality analysis is required. And
Sorry, before one, what is said said to be the reason for treating judges differently from other categories of work, as you understand?
As to the aim, it's very difficult to identify. The explanation, as opposed to the aim, the explanation has been put as, well, they can rely on other matters, like their right to constitutional security of tenure and independence. But as to the aim for excluding them, I shall leave that to Mr. Collins, because I haven't identified that. And the difficulty is that the courts below didn't either. So we see that from Lord Justice Underhill.
No, it's difficult to apply a proportionality test until one knows what one's applying it to. But
yes.
You say you don't know.
Well, we don't know. And no doubt Mr. Collins will be able to enlighten us. But when I use proportionality, I'm perhaps using it to embrace legitimate aim. But in any event, there was no such analysis carried out by Lord Justice Underhill. We don't know what the legitimate aim is, and certainly there was no balancing exercise. So if I can just very briefly take you to the Court of Appeal judgment to make that point good. Core volume, it's MS 217. That's page 45 of the internal numbering, MS 217. And at paragraph 127, it's important to keep in mind that the same definition of worker which we have to consider is used in a variety of different contexts in employment legislation, used to determine the scope of many different pieces of legislation, not only the one directly in issue, yes. This is a field, in other words, which concerns social and economic regulation. From that, Lord Justice Underhill leaps to the manifestly without reasonable foundation test. So that's not appropriate, nor is it a proper foundation for moving on to that test. And then 128, it's important to keep in mind that this is a context in which, on any view, and even if we were wrong about question 3, that's status, there is certainly no discrimination on any of the express or core grounds. That's entirely accepted. It doesn't mean that there should be no proportionality analysis. And then 129, against the background of the authorities to which we've referred earlier, therefore, this is a context in which the court should tread with care in case it inadvertently but impermissibly interferes in an area which is within the province of the democratically elected legislature. And then at MS 219, paragraph 132, what Mr. Stillett submits is that even if that's so, even if there is a right to bring a claim under Section 7, so even if that's so, there are better and more efficient protections available to those who can bring a claim under the 96 Act. We would not necessarily accept the premise of this argument. It might be said the opportunity to bring a case before the High Court, which has a great deal of experience in dealing with human rights issues, is at least as good as the Employment Tribunal, certainly more expensive. However, for the purpose of the argument, we will assume that what Mr. Stillett submits is so. This is not the test in the present context. The question is whether the way in which Parliament has thought fit to protect judges in the exercise of Article 10 rights, in comparison with workers as traditionally understood, was one which was reasonably open to it. In our view, it was policy choice which Parliament made in drawing lines, which it's done in the present context, cannot be regarded by this court as being manifestly without reasonable foundation. So no proportionality analysis at all, not a question of strict scrutiny, none at all, as my lords already identified, no aim identified, no balancing exercise, no weighing of the impact on the appellant as against the aim sought to be realised. That exercise simply hasn't been undertaken.
And no less intrusive means consideration.
Less intrusive means.
Your point is that the manifestly without reasonable foundation test, itself of course controversial, as the ANPS makes clear, but on the assumption that it does apply in the field of economic and social policy, your point is that this is not in the field of economic and social policy at all. It's in the field of employment.
And, well, I probably shouldn't say any more about the manifestly without reasonable foundation test, except it doesn't apply here. Yeah. But it is controversial, and if I may say so, with respect, the court may think it would be right to ensure that some care is taken to ensure it doesn't encroach further and further and further into the important rights under the Convention, but that's perhaps going a step that I don't need to go for. It's simply not applicable in the context of employment rights, and there is simply no authority to suggest otherwise. For the same reasons as given under Article 10, we say that the provisions under Section 230 or Section 191, matters not to the appellant, can be read in a way which is consistent with Article 14, read with Article 10, by affording a meaning which is wide enough to embrace judicial office holders. And that would not go against the grain of the legislation, most particularly the whistleblowing provisions, because as I've indicated, in some cases a contract isn't required at all, so perfectly permissible, available. And if we were wrong about that, we would seek a declaration of incompatibility. But our first point is that Section 3 is perfectly robust enough.
Can I just ask you about one point? The legislation itself, as you pointed out, has been amended in bits to add on those who in various ways need to be protected, some of them without contracts, but most notably with the police constables who have a remunerated office holder status. Now, I just wondered to what extent that comes into the picture in the Article 14 analysis. I mean, does one compare judicial office holders with, or can one compare judicial office holders with constables with a view to arguing that there's a difference in status there? And because if Parliament had decided to deal with this point, one would have expected it to deal with it by adding something on to 47KA.
In terms of if Parliament had wanted to
do this,
include judicial office holders.
Whereas what you're asking us to do is to do something to 230 or 191 in order to do it. Presumably we can't do it by adding something on to 43KA.
The means by which the court reaches the end that we seek isn't particularly important, and indeed under section...
We have to make sure that the means, though, falls within the statute. Well, and the Section 3 really allows us to add on another 43, a bit to 43KA.
The easiest way in my submission would be to deal with it through Section 230 by saying that there isn't a contract required, there can be a relationship which would be adequate.
Would that affect every employment situation or every working situation of that type?
only where one of the convention rights was engaged, and so there was a need to read it conformably with the convention.
What type of working relationships would be affected by that?
Anyway,
In addition to judicial office holders, can you give us any examples?
I'd struggle to, because actually probably most are covered, and we say we're covered as well on a proper interpretation. But there may be some, I suppose, for example, some ordained ministers, for example, in the Preston case. The question whether or not they would be afforded a remedy under Article 10, which would be amenable to a Section 3 construction, would depend upon the issue raised by my Lady Hale in Bates. That is, whether or not Article 10 can be read horizontally as well as vertically. But that would be one example. That I'm sure there's likely to be others, but I can't at the moment think. But it would be office holders who, as I say, in some cases ordained ministers, for example. There may be others who would otherwise fall outside the provisions and were able to rely on Article 10.
Person appointed to conduct an inquiry by the Lord Chancellor or some other minister, would that be a person who would fall into this rubric?
Assuming they weren't caught by any other provision and they were able to bring themselves within Article 10, that is, they'd made a responsible disclosure, or they proposed to make a responsible disclosure, and all the other requirements of Article 10 were met, then, and of course subject to justification, and of course justification may be a role-specific assessment. The fact that it's not justified in this case, or hasn't been established to be justified in this case, doesn't mean it will never be justified. But subject to those matters...
and assuming that there is no contract.
And assuming there's no contract, yes.
It will depend on the type of inquiry as to whether there would be a contract or not.
Assuming one didn't fall within one of the other provisions, then there may well be a role for Article 10 subject to the matters I've just identified, that is vertical, horizontal, and justification. My lady, my lords, having raced through it, believing I otherwise wouldn't finish before 3:30, I'm now at 3:05, but I don't suppose you'd thank me for taking you back to Tangier and so on and filling the time for the sake of it. I'm happy to do so, but if there are any matters...
I'm just checking. Some of us have had such a lot to do with Article 14 that
yes, of course.
it's better to get straight to the nitty-gritty, but if any of my colleagues would like a little bit more on the subject. And of course, Mr. Stillitz is going to deal with it as well, is he not? So maybe we could reserve our fire for him instead of you. So if
I'm sure that would be very comfortable for me.
Well, thank you very much indeed, Miss Monaghan. And as you point out, you don't have a junior, so I can't call upon her to
No.
to follow you.
Unfortunately, no.
Yeah.
May it please your ladyships and your lordships, Protect, the Whistleblowers charity, is very grateful for this opportunity to make some brief oral submissions in addition to the written case we've submitted on this matter. And I propose to confine my submissions to first some short general policy observations on the whistleblowing legislation. Then to make one specific point about Section 191 and how that applies. And then to make some additional submissions on the Article 14 point, which, as you will have seen, was the topic that we majored on in the Court of Appeal. Dealing first then with policy, the whistleblowing legislation was enacted in the public interest and is an important safeguard of the freedom of expression of workers. It benefits, however, not just workers, but the public at large, by protecting those who speak out about wrongdoing in the workplace. In that sense, in Article 10 terms, the whistleblowing legislation protects both the right to impart and the right to receive information. And as my learned friend Ms. Monaghan has pointed out, this court has recognised in Bates van Winklehoff that the whistleblowing provisions protect the right to freedom of expression. And the importance of Article 10 rights in protecting judges specifically from speaking out was recognised by the Strasbourg court in Kudishkina. Moreover, the whistleblowing legislation provides a specific, comprehensive and powerful set of legal protections and remedies to whistleblowers. And again, as my learned friend Ms. Monaghan has demonstrated very fully, the precise extent of the protection has been very carefully calibrated by Parliament and honed through a series of amendments since the legislation was first enacted. And we make this point because whilst in some circumstances individuals may have alternative or parallel remedies available to them, whether at common law or under statute, the whistleblowing legislation has been deemed to be an essential addition to the range of protections otherwise available, and we'd say for good reason. Much of what divides the parties in this case turns on the starting point that is adopted. If one starts from the position that judges should in principle have at least as much protection from being victimised for highlighting wrongdoing as other workers, we submit it's very difficult to justify their exclusion on anything more than quite technical and arid grounds. The principle of judicial independence provides no basis for excluding judges from whistleblowing protection. Indeed, such protection can only serve to enhance judicial independence. Moreover, if providing judges with the full protection of the Equality Act 2010 is consistent with judicial independence, which Parliament has said it is, it's difficult to see why the protection of the whistleblowing legislation is not similarly consistent. This court held in Ministry of Justice and O'Brien that judges are in an employment relationship with the Ministry of Justice, and they do benefit from the full protection of the anti-discrimination legislation. And we say in those circumstances that the absence of a contract, if indeed there is such an absence, provides a very slight and we would submit arbitrary basis for excluding judges from the parallel protections of the whistleblowing legislation. Ministry of Justice and O'Brien is also worth mentioning in the context of my Lord Carnwath's question about what is employment absent a contract. Clearly in that case it was recognised that there can be an employment relationship which is not dependent on a contract but is characterised by doing work personally for another, whether as an employee or as a worker.
Do you mean as a voluntary worker?
Voluntary worker is a different category where there is specific case law on whether that applies or not, and that is perhaps a difficult example because in a voluntary case it's very hard to see any kind of real obligation arising, even in honour in some cases, and so that would be an unusual case, not the one that arises in this particular case. But certainly we would submit that the presence or absence of a contract, if one otherwise fulfills the requirements of Section 230, seems an odd basis for excluding a very important category of judges from the protection of whistleblowing. So that's what we say about the general policy matters. Coming then to section 191, we very much adopt the appellant's arguments, but there is one specific issue we wanted to raise, which is whether the section 191 argument perhaps may prove too much. We say it doesn't, because the concern was raised, well, if the section 191 argument is correct, does that mean judges can claim unfair dismissal? And for that, the answer we say is fairly clearly no. And the reason we say that is most easily explained by reference to the section itself, which is at MS page 864, Primary Authorities, Volume 1, Tab 1. Broadly speaking, Section 191 appears to have been enacted because there was this doubt about whether the Crown could enter into contracts and to cover the case of various types of public servant who perhaps couldn't have contracts as such, but were considered to be deserving of employment protection rights. Section 1911 is, and the remainder of the section, is careful to distinguish between employees and workers. It says the provisions of this Act to which the section applies have effect in relation to Crown employment and persons in Crown employment as they have effect in relation to other employment and other employees or workers. And it's important to stress this point at the outset, that this does not confer additional rights on those who would fall, were it not for the absence of a contract, within Section 233B. It only confers on them such rights as they would have were they within that section, if they are the broader category of workers. If they fall within the narrower category of those working under a contract of employment, they enjoy all of the rights that an employee would enjoy. But this section is not intended to elide that distinction.
Sorry, sir, I'm afraid you'll have to take it a bit more
That's
slowly.
very helpful. Thank you, Mr. Still. It's answered my
Yes.
problem.
Yes.
Yeah.
It may answer mine if I could understand it.
Yes.
I'm not quite as well up to some of the others. Yes, take it again.
So, broadly, under the Employment Rights Act, there are two classes of rights. There are rights which are conferred on employees only, and there are rights which are conferred on workers, which is a broader category.
Yeah.
And under Section 230, they're respectively under Section 233A and Section 233B. Now, if one runs through Section 191, so just pausing there, Section 1911 in my submission simply provides that where you have those in Crown employment, they will enjoy the equivalent set of rights that
They would if they were the...
that they would if they were within one of those.
And so how does that apply to unfair dismissal? Which is
Well, I'm about to explain that to my lord. So if one goes to subsection 2, of the rights listed there, the only ones that apply to workers as opposed to employees, on my analysis, are those under Part 2, which is deductions from wages, and those under Part 4A, which is whistleblowing. Now, there's also some provisions under Part 5, because, for example, the right not to suffer detriment on whistleblowing grounds is under Part 5. But all of the rest of these parts, so Parts 1 to 3, Parts 9, Part 10, crucially, unfair dismissal, those confer rights only on employees, not on workers. And so, if the submission on Section 191 is correct, all that would do would be to entitle judges to bring whistleblowing claims and to bring claims if they were not paid their salary.
Yes, I can see that if that's it. And, I mean, that's not how I understand Miss Monaghan to put it, but maybe she would go along with it.
I now adopt Mr. Stirling's submissions,
Thought you might.
and I'm very, very grateful to you.
All right, well, I think I do. That's very helpful.
Yes. Well, so that was the only point I wanted to make on Section 191, and it's of interest. And I just make this point. You'll note that under the predecessor of this, which my learned friend Mr. Collins refers to, which was the 1971 Industrial Relations Act, the equivalent section referred only to employees, because at that stage that act conferred only rights on employees. It's only since that the employment protection has expanded to cover these two categories of workers. So that's what we say about section 191.
But just so that I understand that exactly, are you saying that if one applied section 191 to judicial office holders, if you held that they were fell within section 191, all you would be doing is giving them effectively whistleblowing rights?
And rights not to have unlawful deductions made from their wages.
Well, yes.
Well, that gives a statutory remedy,
Yes.
Yeah.
which, if we're predicating all of this on the non-existence of a contract, one might think was rather appropriate.
Certainly,
As I said earlier, the very, very unlikely event that one is not paid one's entitlement.
certainly, absolutely. Certainly, we would say there's nothing particularly controversial or surprising about that right extending. Now, I should say that this is on a fairly swift canter through the Employment Rights Act. Those are the ones I've identified. It may be, and we can check overnight, there are one or two
Please
others.
do,
But
yes.
broadly, most of the rights under these parts are only conferred on employees. It's only a limited class under the Employment Rights Act that are conferred on workers as well. So that's the section 191 point. I then turn to Article 14. Now, the purpose of Article 14, we submit, is to ensure that the rights conferred by the Convention are enjoyed equally, without arbitrary or unjustified exclusion from or limitation of the exercise of those rights. It's essentially, we submit, a principle of equal treatment. And it's couched so as to prohibit discrimination generally on any ground, without regard to any exhaustive list of protected characteristics, provided one can identify differential treatment linked to some status, which need not be personal or innate or immutable, as we'll see. Article 14 will be breached, subject always to the question of justification. And so, for example, in Clift in the United Kingdom, the Strasbourg court said, and just for your reference, this is MS 1178, paragraph 60, the general purpose of Article 14 is to ensure that where a state provides for rights falling within the ambit of the Convention, which go beyond the minimum guarantees set out therein, those supplementary rights are applied fairly and consistently to all those within the jurisdiction, unless a difference of treatment is objectively justified. Or, as it was put even more succinctly by the Strasbourg court in Sidabras in Lithuania, Article 14 of the Convention protects...
Where is that?
That is MS 1270, paragraph 38.
Thank you very much.
Article 14 of the Convention protects individuals in similar situations from being treated differently, without justification in the enjoyment of their Convention rights and freedoms. The requirement of justification, in practice, we say, places a burden on the state to explain why it's necessary to exclude or limit the application of a right to certain categories of people. And so, mirroring Ms. Monaghan's submission, we submit the Court of Appeal did err in three respects in its analysis of Article 14. First, it adopted an unduly narrow interpretation of other status. Secondly, it wrongly focused on the availability of potential other avenues of complaint for judges as going to the question of whether judges are in an analogous situation to other workers, rather than looking at those matters as it should in the context of the question of proportionality. And thirdly, we say the Court of Appeal erred in its approach to justification by failing to identify a relevant legitimate aim or addressing adequately the question of proportionality itself. So, In the brief time available to me, I propose to just expand on those three submissions, if I may. First of all, other status. Both the Strasbourg and domestic courts have taken a very broad approach to discrimination on grounds of other status. And a relevant status may arise solely by virtue of belonging to a particular category recognised by the law, by having a particular legal status or a particular type of legal relationship. And the best statement of this, I only propose to go to two authorities, but the best statement is in Clift and the United Kingdom, which is MS 1161, Primary Authorities tab 15, if I could take that authority, please. So Clift was the case of discrimination based on the length of a prisoner's maximum determinate term of imprisonment, the distinction being between those sentenced to more or less than 15 years. So it was a status entirely imposed on the individual externally by virtue of their wrongdoing, but essentially one that was imposed by the relevant trial judge. And in looking at this, the Strasbourg court very helpfully elucidated this concept from paragraph 55 onwards. So it's 1176, MS 1176.
I'm sorry, I'm thinking that in the recent case of Stott, there was a large discussion of this whole subject, including Clift. And
there was, and it made me...
I'm not sure that my lord found Clift very helpful.
Yes, I should say I was...
I'm very conscious I was in the minority there.
No, well, quite. But this is taken in particular by Lady Black into account there. But I just think this is the most helpful sort of summary of it, if I may. And I hope not unduly taking up the court's time. But at 55, Article 14 does not prohibit all differences in treatment, but only those differences based on an identifiable objective or personal characteristic or status by which persons or groups of persons are distinguished from one another. Then at 56, the court recalls that the words other status and a fortiori the French toute autre situation have generally been given a wide meaning, see Carson. And at the foot of the page, the court observes at the outset that while a number of the specific examples relate to characteristics which can be said to be personal in the sense that they're innate characteristics or inherently linked to the identity of the personality of the individual, such as sex, race, and religion, not all of the grounds listed can be thus characterized. And then at 58, in finding violations of Article 14 in a number of other cases, the court has accepted that status existed where the distinction relied upon did not involve a characteristic which could be said to be innate or inherent and thus personal in the sense discussed above. In Engel, the court held...
We've been through all these.
I mean, it's all... I raise it because I didn't manage to persuade the Court of Appeal on this.
I found them exceedingly unconvincing, I must say, but there we are.
Well, it is what it is, but my lord, this is a very wide statement which was not accepted by the Court of Appeal. The Court of Appeal, at paragraph 121 of its decision, says that the present case is not another status case because whether you have a contract or not is not a personal characteristic. And in my submission, that...
That's too narrow, obviously.
Plainly,
but I mean, we've dealt with this in Stott, and I'm not sure.
Exactly. So perhaps I needn't take
some
any...
of us weren't in Stott, of course, but I mean, your essential point is that status can be acquired either because you inhabit a particular class by dint of your gender or your birth or your ethnic origin, or it can be imposed upon you.
Yes.
And there's no reason to suppose that by agreeing to be appointed a judge that you're precluded from acquiring a status.
That's precisely the point. I mean, it can be imposed upon one, as in a prison sentence or, for example, immigration status. It can be a matter of choice, for example, deciding to become a KGB officer or a judge. But the point is, this is...
Interesting comparison. You may want to rethink that, Mr. Stevens.
Well, I don't seek to draw any broad...
One carries far more advantages than the other.
All I would say is that they are both occupational choices. But they're nothing to do with the way one is born, or even some sort of more fundamental lifestyle choices that might acquire. It doesn't have to be any inherent or innate characteristic. And this ought to be relatively trite. The only reason I labour the point is because the Court of Appeal didn't seem to see it that way. And we say that the status of being in employment without a contract is amply sufficient to satisfy other status, and that the Court of Appeal was wrong to require some kind of more personal characteristic. But the same might be said of the public sector tenant in Larkos, or the lower-ranking soldier in Engel, or the former KGB officer in Silvergrass. So we say clearly that was an error on the court, with respect, on the Court of Appeal's part. We then move on to what we submit as the second error in the Court of Appeal's judgment, which is that of analogous situation. Again, this ought to be well-trodden territory, and I had in mind to refer to my Lady Hale's speech in AL Serbia, judgment in AL Serbia. If you could just very quickly turn that up. It's the last authority I intended to go to. That's at MS 1577, which is Authorities Volume 2, tab 37. A case based on asylum status, but the key passages are paragraphs 24 and 25, which is at page MS 1587, where my lady says the classic Strasbourg statements do not place any emphasis on the identification of the exact comparator. To ask whether differences in otherwise similar situations justify difference treatment. Lord Nichols put it in this way in Carson. The essential question for the court is whether the alleged discrimination, that is the difference in treatment of which complaint is made, can withstand scrutiny. Sometimes the answer to that question will be plain. There may be such an obvious relevant difference between the claimant and those with whom he seeks to compare himself that their situations cannot be regarded as analogous. And then at 25, nevertheless, in fact, in the last sentence of the quote, then the court's scrutiny may best be directed at considering whether the differentiation has a legitimate aim and whether the means chosen to achieve the aim is appropriate and not disproportionate in its adverse impact. Nevertheless, it's a very helpful analysis in Strasbourg case law on Article 14 carried out on behalf of Mr. AL shows. In only a handful of cases has the court found that the persons with whom the complainant wishes to compare himself are not in a relatively similar or analogous position. This bears on the observation of Professor David Feldman, quoted by Lord Walker. The way the court approaches is not to look for identity of position between the different cases, but to ask whether the applicant and the people who are treated differently are in analogous situations. This will to some extent depend on whether there's an objective and reasonable justification in treatment, which overlaps with the question about the acceptability of the ground and the justifiability of the difference in treatment. This is why, as Van Dyck and Van Hoof observe, in most instances of the Strasbourg case law, the comparability test is glossed over, and emphasis is almost completely on the justification test. And at the very foot of the page, my lady says, this suggests that unless there are very obvious relevant differences between the two situations, it's best to concentrate on the reasons for the difference in treatment and whether they amount to an objective and a reasonable justification. And we wholeheartedly adopt and endorse that approach, unsurprisingly. So here, we compare the position of a contracted worker with that of a non-contracted worker. The former can blow the whistle and enjoy the full protection of the whistleblowing provisions. The latter cannot. And that, we submit, should be sufficient to get past this stage of the analysis. The Court of Appeal decided that judges were not in a relevantly analogous situation because they have certain protections that others may not have, such as security of tenure up to a point and limited grounds on which they may be removed from office, or that by virtue of working in the public sector, they have the possibility of a claim under Section 7 of the Human Rights Act. But the fact that there are differences between the circumstances of judges and others does not mean that judges who wish to blow the whistle, or contracted workers who wish to do so, aren't in an analogous situation. Critically, we are here concerned, in this case, with alleged whistleblowing detriments, not dismissal. The fact that judges are ex hypothesi wholly deprived of the protection of Part 4A of the 1996 Act, when if they were employed under contracts, assuming they're not, they would enjoy such protection, ought to be enough. The question of alternative recourse, which may somewhat ameliorate the position of judges, ought to go to the question of proportionality, not the question of analogous circumstances. And so that brings me to the third basis on which we respectfully say that the Court of Appeal erred, and that is on the question of justification. And we here very much adopt a remark that came from my Lord Conworth to my learned friend Ms Monaghan about what is the legitimate aim here, because we do not even get to the question of the proportionality balance unless a legitimate aim has first been identified. And that puts the respondent in a difficult position, because in their lengthy case, we have struggled to identify what legitimate aim they say this exclusion of judges from whistleblowing protection has. Now, they haven't suggested, nor could they, we say, that bringing judges within the protection of the whistleblowing legislation would somehow be inconsistent with the independence of the judiciary. That would be a very difficult argument for them to raise in circumstances where whistleblowing protection can only enhance independence, where it's been conceded by the government in Ministry of Justice and O'Brien that the protection of anti-discrimination law is consistent with judicial independence, and where judges are fully and explicitly covered by the protections of the Equality Act under Section 50 of that Act, including a prohibition on victimisation under Section 27. Nor could the respondent realistically try to say the existence of a contract is somehow integral to the enjoyment of whistleblowing protection, because there are various examples under Sections 43K and 43KA of the Employment Rights Act of those without a contract who do enjoy the protection of the whistleblowing legislation. For example, those doing work experience, those who are victimised by a third party they're not in a contract with, or indeed police constables. So we say that we don't even get to proportionality in this case. In the absence of a properly identified legitimate aim, nowhere has a rationale been put forward for excluding judges. And in those circumstances, there is a breach of Article 14 combined with Article 10. We do say that the availability of a victimisation claim under Section 27 of the Equality Act poses a particularly stark difficulty for the respondent in seeking to identify a legitimate aim. And we put this example before the court. Let's say a district judge raised a complaint that the resident judge in their court centre had sexually harassed a member of staff. And that district judge was then victimised for having raised that complaint. They would be fully protected under Section 27 of the Equality Act. But let's say they made a slightly different complaint. Let's say they complained that the resident judge had taken a bribe. Very, very serious complaint. And they were then victimised for that. No whistleblowing protection at all. Why? Why should the former be fully protected by the law and the latter have no protection at all? We say there can be no conceivable principled reason for depriving judges of that sort of protection. That brings us then to the question of proportionality.
I think you've actually unless you're taking Miss Monaghan's time that she didn't use. Is that what you're doing?
Well, I'm about to sit down, so I hope neither to do that nor to overstay my welcome.
Finish your submissions, that's fine.
I'm just going to come very briefly to the question of proportionality and simply endorse what has been said by Ms Monaghan about whether the approach is one of manifestly without reasonable foundation. Whatever the merits of that case, this is not a case about Parliament allocating scarce resources and benefits in a particular way, which are, in the very utmost of policy considerations. This is simply a case about whether an important legal right should be deprived to a particular class of person. And so we say ordinary proportionality arises, and we say that the availability of potential other remedies, whether it's internal or under section of the HRA, doesn't begin to establish that it's proportionate in the sense of necessary and there being no less intrusive measure for this exclusion to be applied. But as I've already said, that we do not even get to that unless a proper legitimate aim has been identified. Finally, on remedy, we would submit that it is not difficult in this case to apply Section 3 if needs be to correct the breach of Articles 10 and 14. One way would be to amend Section 233C and add a limb relating to those in an employment relationship with their employer. Another way might be to add a further Section 47K 1E, just simply to add a holder of judicial office as an alternative limb of the additional categories protected by whistleblowing. Another option, if one's looking at the Section 3 obligation, if the court isn't otherwise persuaded under Section 191, it is to read that purposively in such a way as being capable of extending to judges. But there's none of these, as Mr. Justice Underhill, as he then was said in Coleman and Attridge Law, the drafting isn't really of the essence. The question is, does it go against the grain of the legislation? And we would submit that there's nothing in this proposed result which goes against the grain of the legislation.
Well, it may not go against the grain of the legislation, but is it open to us to add a category?
Well, in my submission, it is. I mean, it can be done in a sort of softer and harder-edged ways. But, I mean, Coleman and Attridge Law is a classic case where Mr. Justice Underhill upheld simply, drafted an extra section of the legislation to make sure it complied, as long as it doesn't go under Gaydon and Goden-Mendoza against the grain.
The facility afforded us by Section 3 is to interpret the legislation in a way that is compatible. And I mean, it might be said that that's a very different animal from adding a new provision which has been omitted.
Well, the courts have done it on numerous occasions. I mean, an example which isn't before this court is a case of Wandsworth, London Borough Council and Vining, where there was held to be an unjustified exclusion of, ironically, parks constables from the collective redundancy provisions. And the court, having found there was no justification for that breach of Article 11, simply corrected the legislation. And say Coleman and Attridge Law is another example. The question, and as I say, there are ways of doing it which wouldn't require being so specific.
Well, the simplest way would be to read Section 230, subsection 3B, as any other contract or legal arrangement.
Yes, that would be, or to use the phrase from O'Brien, those under a contract or otherwise in an employment relationship.
Yes, but that has the problem of people wondering what employment means in that context, whereas, yeah.
But
that's the simplest.
Yes,
not adding a whole new.
Yeah.
Perhaps not, but if otherwise there is a breach of the convention, certainly we would submit this is not a case where it could be said to go against the grain of the legislation to correct it in that way. And for those reasons, we submit that that would be the appropriate remedy. I have gone over my time, and I'm grateful for the court's indulgence. I should say that in respect of the matters I haven't made oral submissions on, Protect adopts the submissions that my learned friend Ms. Monaghan made on behalf of the appellant. But unless I can assist you further, those are the submissions made on behalf of the appellant.
It appears not. Thank you very much indeed, Mr. Stilios. Thank you. Now, do you wish to make a start?
Well, my lady, the court might get better value from me if I make a fresh start first thing in the morning, I suspect, having had quite a lot of oral submissions today. I'm in your hands, my lady, is how you want me to proceed. If I'm asked to express a preference, tomorrow morning would be my preference.
I'm asking you to express a preference, yes. It will be at Miss Monaghan's expense, because that means we lose the quarter of an hour, but Miss Monaghan seems fairly relaxed about that.
We'd add the timetable that we had provisionally agreed, subject to the court's approval, provided for me to start tomorrow morning.
It did indeed, in any event. Yes,
3:30,
that's right.
so, I can still do that, I think.
Well, then we'll look forward to that tomorrow morning.